All right, thank you. Um, Good afternoon, everyone. My name, as stated, is John Willen. These are your presenters for today. Can you go back to the last screen, Scott?
Oh, you
Um, Obviously, myself, Peter, and Scott, but I did want to raise everyone's attention. Jeremy Kilber was unfortunately unable to present here today. He had a conflict, so he won't be joining us, unfortunately. So next slide, please. All right, so we want to start off today's presentation discussing this new law. It's created kind of a stir in the community, but hopefully we have some very good news at the end of the presentation. Specifically, this is AB 398. This is Nevada's new prohibition of defense within limits, and this is relevant to your insurance policy. Next slide, please. I want to start off by first discussing what is a self-depleting insurance policy. Now, some of you who have been involved in litigation are familiar with this, with how your insurance works. But for those who haven't, a self-depleting insurance policy essentially is a liability policy that reduces its liability limit dollar for every dollar spent on attorney's fees, costs, or expenses. It is also commonly referred to as defense within limits policies. And this practice applies to various types of policies: auto, general liability, errors and omissions, professional liability policies. The one that's probably most important to most of you is the professional liability policy. There's a couple of factors I did want to raise. A self-depleting policy doesn't deplete the limits, as we'll go into the example after this, until you complete your deductible. However, please note there's something called a first dollar coverage policy. Dollar one is another name for it, where the insurance company will pay for the attorney's fees and costs for litigation, where you don't have to exhaust your deductible first. Next slide, please. So how do these policies work for those who don't have an understanding yet of what it is? We made a hypothetical situation where we selected ABC Architects, who has a self-depleting policy of $100,000. This is a PL policy with kind of a cutesy name here for you, insurance company. Let's say hypothetically, because no design professional ever violates the standard care, there's a substantial design error that does create some financial loss to the client. Well, in this case, here for you, insurance company, when evaluating a claim, will hire an attorney from its approved panel, for example, us, to come in and assist in your defense and assist in protecting you from the claims, and also to evaluate the claims and reach a reasonable value. So in this case, let's, under our hypothetical, the insurance company expends $20,000 pre-trial. Now, again, this is simplistic hypothetical. Most of the time, litigation, especially litigation involving millions of dollars, it's going to be substantially bigger. But in this case, assuming you have either a zero deductible or you exhausted your deductible, if $20,000 in fees and costs are applied against your policy limits, then it would drop to $80,000. This is the amount you would have available for the indemnity portion, or the portion in which you are covering an alleged damage that arises out of your design, professional design, or services. And that's what a depleting policy in general looks like. Again, this is very simplistic, but understand that depending on the type of policy, after your deductible, dollar for dollar starts going down. So you may have a $100,000 policy, $1 million policy, 10 mil, 5 mil. That may not be the amount at the end of the litigation. Okay, next slide, please. So why did the Nevada legislature do this? Why did they make this new AB 398 law that we'll be talking about a little bit? We analyzed the situation, and we believe that there are three factors that lead to this kind of concern as to why this came about. For example, one concern that was raised is that the insured, or the client, in this case yourselves, you sign a policy, you think you have $100,000, you go through a year, 2 years of litigation. Next thing you know, at the end of the day, you only have $50,000, or in this hypothetical, $80,000. Certain people were complaining that, wait a minute, I paid for $100,000, why I only have $80,000? So that was one of the factors that we determined was raised as to why this law came into fruition. Dovetailing to that, the second factor involves litigation is very expensive. You're paying for court costs, you're paying for experts, you're paying for the attorney's time, attorney's effort. You're also paying for a lot of litigation-related costs. For example, if you have to do depositions out of state, that's travel costs. You're also paying for pretrial workup, for example, exhibits that need to be done, managing the paperwork, so to speak. At the end of the day, sometimes the costs are significant, depending on the size of the case. We've seen multi-million-dollar cases that have very large fees and costs. So what happened is there was a concern raised that, well, because litigation costs are so expensive, there's very little left at the end of the day if you have a burning limits policy that maybe is lower than the projected complexity and claim value. And so claimants, particularly our good friends, the Plaintiffs' Trial Lawyers Association, were complaining, well, we're settling not for $100,000 in this hypothetical, but $80,000, and that's not appropriate. And that was one of the complaints raised. And then the third factor is, in our hypothetical, there was a risk that ABC Architects Inc. in this situation may be on the hook for excess. For example, a judgment comes in at $100,000, your burning limits after your deductible is only $80,000. The insurance company, under its contractual obligation, pays $80,000, and then you're on the hook for $20,000. That was another concern that was raised as why this law came into fruition. Okay, next slide.
But let's be clear, the plaintiff's bar is really the driving force here. They're the ones that want to litigate the heck out of a case and still end up with the benefit of a full policy limits. Before this, plaintiffs' attorneys really had to be more strategic in how they addressed this and communicated the true nature of this policy to their clients, the plaintiffs. By the passage of this law, the plaintiffs' bar can kind of wash their hands of any responsibility here, in saying, well, we're going for whatever the state limits is, and too bad. So that's my 2 cents there.
Yeah, I'll also add, in my experience, prime contractors would complain all the time. Well, wait a minute, I have a $1 million CGL policy, and why am I on the hook for $1 million, or my insurance company on the hook for $1 million, and your insurance company is not? That you're able to depreciate or reduce these limits. But I think Mr. Stacy's correct. It is primarily driven by the plaintiff's bar, an opportunity to negotiate at full policy limits versus a reduced limits based on costs. And the plaintiffs understand that when you litigate a case, a sizable amount of legal fees can reduce the limits. And again, what we're seeing in mediation in Nevada in particular is mediators coming in and saying, well, they only are going to have X amount at the end of the day. They're asking for our projected fees and costs so that they can calculate out how much is available. So again, this is really driven by the plaintiff bar in the state.
So now we move on to, what does AB 398 actually mandate? And here is the language of AB 398. And we can just go ahead and read through it. Chapter 679A of NRS is hereby amended by adding thereto a new section to read as follows: notwithstanding any other provision of law, an insurer, including without limitation, an insurer listed in NRS 379A.160 shall not issue or renew a policy of liability insurance that contains a provision that, 1, reduces the limit of liability stated in the policy by the cost of defense, legal costs and fees, and other expenses for claims, or 2, otherwise limits the availability of coverage for the costs of defense, legal costs and fees, and other expenses for claims. If we look at section 2, the provisions of this act do not apply to any contract for liability insurance existing on October 1st, 2023, but apply to any renewal of such a contract. So what is the impact of AB 398? It is that a policy of liability insurance must now include defense costs outside of the limits of liability, and defense coverage must be available to the insured. Interestingly enough, Nevada is the only state to outright prohibit self-depleting insurance policies to date.
All right. So why should you care? Well, there's a bunch of insurance companies. Why do I care? We've gone through and analyzed why. This is the law of the land as it stands today. We have some good news coming, but this is the law of the land today. And why should you care? First of all, your company that does have a depleting policy, when you go for renewal, after October 1st, 2023, which was about a month ago, because of AB 398, now you're not going to get the same type of policy that you had. Now, you'll get something different, and we'll go through some of those items, but you're not going to get the same thing. Your current carrier may choose to discontinue offering PL coverage in Nevada. We've seen or heard, at least, some carriers have decided this is too much of a headache. We're going to pull out, or we're just going to go to excess and surplus. And what we're also seeing is when you come to renewal, again, there's a potential because of this issue that your premiums could rise, or you might be offered something extra that you're going to have to do to your policy that you didn't have before. So those are factors to take into consideration. This is why you have to care. Why this law created kind of a storm, so to speak, in the state of Nevada, particularly for various design professionals and others that have this kind of insurance coverage. All right. Next slide. There's some caveats to AB 398. So if an insurer is authorized to transact insurance in Nevada as a captive insurer, its policies are not, will be governed by this new law. Does not appear to apply to unauthorized or non-admitted insurers. This means that certain insurance companies that are not part of the pool will not be bound to this law. And it does exempt excess and surplus lines. That's why some of the carriers are doing that. So if carriers are not part of the insurance pool, there is a risk that if they go insolvent, there's not coverage. So that's something to take into consideration. Next slide. Other caveats to note is the new law does not require unlimited defense costs. And it does not prohibit insurers from requiring self-insured retention. Next slide. The new law doesn't preclude insurers from excluding particular risks, risks that are not covered by routing liability limits. Okay, next slide, please. These are important points to consider when analyzing this issue. AB 398 is the law of the land, and there is definitely litigation that is contemplated. We've heard certain groups are going to fight this law, while others are going to accept it. When you check your contract, this is an important point. In many of the contracts we've seen, there's a requirement that the insurance be admitted. So if you do check your contract and the insurance is supposed to be an admitted insurer, you're going to be bound by this law. So review your contracts carefully and determine if this is an admitted insurer or not. And if you do get an insurance carrier that isn't admitted, then you could be in breach of contract. This is a very important factor to know. And finally, as the insurer numbers go down, premiums and risks are impacted. Next slide, please.
So here's some potential good news. On October 30th of this year, the Nevada Division of Insurance held a public hearing on the adoption of Regulation LCB file number R029-23. And it's a clarification regulation of AB 398. I was actually present at this hearing. There were a few people who spoke on behalf of various organizations, including insurance companies. And so as a result of this regulation, and it's been slowly put into form based upon some of the uproar that occurred after the passage and approval of AB 398. The Insurance Commission noted the various objections to applying the law to design professional PL policies, professional liability policies. So first, a policy of liability insurance includes only a policy of casualty insurance that one, this is the regulating language, provides insurance against legal liability arising from the ownership or operation of a motor vehicle as defined in NRS 485.050. Two, provides insurance against legal liability arising from the ownership of housing that is occupied by the owner as the primary residence of the owner. Three is a policy of commercial general liability insurance. Four is a policy of commercial automobile insurance. Or five, provides insurance covering the professional liability of a provider of healthcare as defined in NRS 418.017. So the good news is, with regards to professional liability coverage, via this regulation, assuming that it's going to be approved, which it looks like it will be, it's only going to pertain to professional liability of a provider of healthcare. I can tell you at the hearing there was a representative from the healthcare industry of Nevada, and they were not happy that the professional liability insurance that's going to be limited under this regulation only applied to healthcare providers. And of course, the concern was that the healthcare and the professional liability insurance with regards to healthcare providers was going to go up substantially. With regards to another aspect of the regulation, the provisions of AB 398 do not apply to one, a risk retention group, liability insurance owned by its members as defined in NRS 495E.110. Also, captive insurance, an insurance company set up and wholly owned by a non-insurance company to act as a direct insurer or reinsurer for its parent company that does not cover third-party liability. Three, a non-admitted insurer as defined in NRS 685A.0375, which Mr. Wendland discussed as to what a non-admitted insurer is. And with regards to the stated reason for the regulation by the Nevada Division of Insurance, we've quoted it, and it is, quote, Nevada businesses as well as local governments and nonprofit entities will benefit from this regulation, which is expected to help with both the availability and pricing of the types of liability insurance products that are written with the cost of defense included in the policy's liability limits. Without this guidance, it is expected that numerous carriers would leave Nevada's insurance market and policies would see extreme price increases.
I think from that takeaway, it's still a very uncertain position what exactly this legislation, coupled with the Commission on Insurance regulation, will ultimately arrive at. Based on the hearing that Scott attended, it's favorable that we will get something that is clarifying and maybe go so far as to say that it's not going to apply to design professional liability policies. Since there is currently that uncertainty, we invite you to definitely raise this issue with your insurance brokers and insurance carriers. As John mentioned, some of the carriers are coming up with at least some temporary solutions to address this, whether they offer a separate add-on defense component. Unfortunately, you'd probably have to pay for that component, and or whether they are going to then be non-admitted, non-qualified insurers so that they can avoid some of this regulation. And unfortunately, as John mentioned to start out with, some may decide to leave the state and stop writing in the state of Nevada. That's the drastic and unfortunate aspect. But we hope if the Commission of Insurance acts on this promptly, that we'll have some better clarification to move this forward, or at least, give us clearer direction on how we can keep our insurance policies in place that are, by their very definition, depleting policies. So with that, I do think we have a couple of questions, or at least one. The first question is, how do I know what kind of PL policy I currently have? Is it stated somewhere that I currently have a depleting policy? And the answer to that is yes. It will state that. It won't. It may not say it's a depleting policy. Most do, however, but it will at least say that it's a policy with defense within limits. And that means, as John was talking about earlier, that your overall policy limits, if you're carrying, for instance, a $1 million per claim and a $2 million aggregate policy, if a claim is made and you start incurring legal fees and expert fees and whatnot, that those defense fees, the legal fees and expert fees and court costs will deplete the per claim limit. And most policies will have clear in the full policy endorsement will outline all of that.
Yeah, I would also add to what Peter was mentioning is your best source is your own brokers. Go to your broker, ask all the questions you need to ask, particularly about this new law. It's only been in existence for 1 month. Some people have already experienced the issue. But the other element is we anticipate litigation. So the commissioner, as Scott was saying, is trying to head that off. We anticipate litigation will be brought by certain insurers that are not being exempted under that regulation that we just went through. So if you have any questions, you don't fully understand what kind of policy you have, call your broker, go through it, make sure you understand the ramifications.
And with that, certainly if people have some other questions, they can, on that particular aspect of our presentation, they can continue to post in the Q&A section. But otherwise, we'll move on to the...
Oh, wait, Peter, there's a bunch of new questions that have popped
Okay, all right. Almost got out.
All right, let's see. Question, do you need to carry a separate Nevada endorsement per policy if you are an out-of-state architect. And again, just so we're clear, we're lawyers, we're not insurance brokers. So we have to be very careful in our explanation here that we do not give insurance advice. That is, you have to be an insurance broker to do that. So my suggestion is you go to your broker first and ask this question. However, I have seen out-of-state architects in this state, and I've not seen a specific Nevada endorsement in some of the policies that we've been working with.
But that is likely to occur if the current legislation remains the law of the land.
Right.
We will start seeing that in undoubtedly as riders and endorsements to policies. But again, that's something you're going to have to specifically check with your broker about. Then the next question is this for errors and omissions or business liability or both? The most of you will, certainly architects will have a commercial general liability policy, an auto policy, maybe a combination of the two, and then a separate errors and omission or professional liability policy. This would be applicable to the professional liability or errors and omission policies. Those are the ones that are depleting limits, and therefore obviously are of most relevance and concern to architects, is that covers your actual professional services. The commercial CGL policies and auto policies, those are both occurrence-based, and the defense fees and costs are outside of the policy limits. So I hope that explains that.
Actually, to go back to one of the questions about the endorsement, you don't have to change anything right now. It's only when you renew in the state of for the state of Nevada. So your current policies are fine. You don't have to run to your broker today and say, "Oh my God, I need a Nevada endorsement." Just understand that when you do renewal and you plan on working in Nevada, there may be a requirement then to get this endorsement for compliance with this law, unless this regulation goes into effect, which we're fairly confident it will. So, any other questions?
I think the last question.
I don't. Yeah.
I'm not sure of the history on who was the biggest proponent of this. I do know it was someone who is a trial attorney, and so that as we started off this, it is certainly a pro plaintiff's attorney position to get rid of declining limits policy. So it hurts the insurance companies, and therefore it has a negative impact on architects in the sense of premium and availability in line with every other state. Usually California is the leader in some wacky stuff, but this time it's Nevada. So here we are. And with that, we'll focus on, so what can we do? What can we do as a result of this pending situation? It's also a reminder on some of the key aspects of your services and how contracts plays into all that. So now we'll move into this part, which is contracts. What do we do? So that's next slide, please. So what are they and why do we care? So what is a contract? It's an agreement between two or more parties creating obligations that are enforceable or otherwise recognized at law. The writing sets forth such an agreement. If you've dealt with me in any contract negotiations, you will know that I will always say, and a lot of attorneys will always say, if it's not in writing, it didn't happen. And you know, many cases come down to he said, she said type of situations. Well, a written contract establishing the ground rules tries to eliminate a lot of that back and forth oral and oftentimes hearsay type of evidence. It's the contract that establishes the lay of the land and the rules by which you govern the relationship. So why have a written contract? As I say, it establishes the rules of the game, outlines your scope, and it's intended to allocate risks and rewards, including now how to get around this new legislation, AB 398. It also develops a framework for dispute resolution in the event of a problem, and with a nod to the co-sponsor of this seminar, it's also required. The state board has a great publication on the written contract requirement. If you haven't looked at that, you certainly should, because except for a few caveats or exceptions, architects are required to have a written contract with their client. So what happens when you have a bad contract? Well, that exposes you to liability beyond your scope of services. It exposes you to liability that is potentially uncovered by your professional liability insurance. That means you've assumed obligations that are not insurable and or have nothing to do with your professional services or making representations or warranties or something like that. Then it also exposes you to potential liability beyond what your insurance coverage is there, what your policy limits are. This is particularly relevant in light of AB 398 because we used to, as we'll discuss a little bit, you could write a limitation of liability and negotiate that with your client to cap your liability at no more than the available proceeds of your insurance. Well, that was taking into consideration the declining limits aspect of that. So now the language would be slightly changed and or the impact would be different given this new legislation. And then lastly, a bad contract might expose the individuals in the company as well as the company itself to more exposure than could otherwise have been negotiated in a good contract. Insurance. Now that we have AB 398 in place, it places a significant burden on how we address this as design professionals, pending perhaps the directive and regulation from the insurance commissioner. We anticipate that clients will now have to mandate policies that comply with this new legislation. It means, as I was saying, that limitations of liability will have to be adjusted. Contract language addressing the particulars of insurance requirements will have to be reviewed in your contract to make sure you're in compliance and not creating an unnecessary and unforeseen breach right off of the bat. Okay, so again, this is something we will work in tandem with your insurance brokers to come up with language that is both compliant with the policies that are being written, but also the legislation itself.
Okay, standard of care. These are standard care clauses in contracts that define the standard of care. Why should you care? We all know design professionals achieve or strive to achieve perfection. Many of you do reach perfection. However, at times, perfection may not be achievable. And liability exposure generally arises when you go into litigation, you find out, wait a minute, I thought these plans were perfection, yet there's defects there's issues, there's another architect coming in there criticizing your design. So perfection is not the law. You're not obligated to be perfect. There are errors that can occur in plans, even plans that comply with the standard of care. In litigation, an expert's going to come in and he's going to say, this, and this is wrong with your plans. He's going to try to blow up and maximize all the defects in your drawings, some of which arguably may be within standard care, meaning it may look like a defect, it may be a defect, but it's not liable. Here's why it's also important to be very careful when studying your contracts. Any kind of clause that requires you to perform beyond the standard of care, the highest standard of care, world class, first class, standard of the greatest set of architects that ever resided. Those are beyond the standard of care and practice. And also watch for standard care obligations that require you to follow a standard that's outside your area or your locale. For example, a European standard. We've seen that in contracts. By accepting a standard care that is beyond the typical standard, you are exposing yourself and your policy to liability for something that your colleagues in the same locale may not be responsible for. It drives up insurance costs. It drives up your cost of litigation, because we will be fighting to establish the standard of care, not the world-class standard of care. And you may be compensated for the standard of care of Nevada. Yet the owner, and we see this primarily in large-scale projects, will say, well, this is a one-of-a-kind project. This is a world-class standard of care. Therefore, any defect, even one that would fall within the standard of care, is a violation. Good. All right, so what is the standard of care? As stated, is not perfection. It is what the reasonably prudent architect, engineer in the locale would do. Standard care does evolve over time. For example, something 20 years ago may not be the standard care today. It is also unique to the discipline or sub-discipline you're involved in. Can also be unique to the project. For example, applying some kind of a nuclear power plant standard to a residential project would make no sense, right? When the standard care is properly defined, you'll limit your exposure to those professional services within your scope. And it requires expert testimony. And this is something we want to bring to your attention. In litigation, the plaintiff is going to go hire an expert in your field. But this expert may not even be from Nevada. Could be from California, could be somebody even international. They're going to come in and they're going to try to define the standard of care. And this is why it's important to catch this in the contract phase. If you have a standard care that's different, it's greater. Now these experts can go in and define it and exceed what you would consider to be the reasonably prudent architect in the state of Nevada. This is why this provision is critical in your contracts. It's critical to catch during negotiations. Make sure your standard care is the right standard care. What does bad standard care look like in the contract? Well, it seems kind of evident, right? It seems kind of commonsensical, some of which I gave you, but perform to the highest standard. Code compliant. Now that's a little bit interesting because the standard care can include compliance with code, but code compliant could mean some other code. So be very careful that you don't use vague terminology. The best, the most qualified, highest level expertise, non-negligence. Here's an example of what we would propose as a good standard care. Now, again, to be very clear, this is not legal advice. But we came up with some language that you can look at and see if this applies in your contract situation. There are many other ways of saying it. But in this case, we have an Article 2. And you can see when you go through it, it says the architect shall perform services consistent with the professional skill and care. Here's a key term: ordinarily provided. Again, we're not talking world class, first class, unless it is that kind of a project and you are properly compensated for that. Provided by architects practicing the same or similar locality. So we're not talking about somebody in Italy. We're talking Nevada, or arguably somebody at least in the region under the same or similar circumstances. Again, not the nuclear power plant. We're talking residential project. And architect shall perform its services as expeditiously as is consistent with that standard of skill and care. So again, this is just an example. You can see the source material. It's the B101. We have written language similar. In fact, not to toot our horn, but we've written better language than this. The key important element is assuring that you attach the proper language, and you can see how words matter. Just take a look at the word ordinarily. That is important to have. One word can change the entire meaning of this provision. So again, this is just an example. Each one of you, when you do your contract negotiations, can kind of refer to this and look for elements of similarity in your negotiations. Now, the exception is if you agree to a first class or world class standard of care. You can do that, but you better be paid first class and world class wages.
And to add on to that, before we get into the next section, which is the liability, don't get me wrong, a bad standard of care will expose you to liability, in addition to paying attention to the provisions we're going to also discuss. But, you know, to John's point, if you agree to provide to the highest standard, then hopefully you do. If you don't, then there's going to be a potential gap between what is covered by your insurance. Your professional liability insurance covers you for the applicable standard of care, which is the ordinary, everyday architect providing under similar circumstances and similar locality. If you've agreed to perform to the highest standard of care, the insurance company may issue a reservations of rights letter and say, we'll cover you for the normal part, but you're on the hook for anything above that. So that also exposes you to potential excess liability. In addition, if you agree to use of terms that an owner commonly tries to insert, that you will perform as an expert or provide a particular expertise. And some architectural firms, in fact, run afoul of this on their websites by referring to their particular quote expertise. Maybe take a look at your websites on that issue. You don't want to put yourself out as an expert. You want to put yourself out as one with a tremendous amount of professional experience in a particular type of design or area. But an expertise means an expert, and that is not what the standard of care is. It's being an expert is raising that standard of care, and you could be subject to those same reservation of rights or performance expectations. And then lastly, one particular area of the law that is constantly creeping into greater use and it shows up in owner-driven contract languages is trying to impose a fiduciary duty, an obligation of, absolute trust and loyalty to your client. That is not the standard of care. Agreeing to such language, again, could expose you beyond what your insurance covers. A fiduciary is the highest type of agency relationship, imposing additional duties and obligations and loyalty to your client. And so it is not what is required by law of an architect. An architect by law is required to perform to the standard of care unless you've agreed to a greater obligation in your contract. So again, that's why there's great importance in having defined this and not agreeing to additional language. Now, some of the other areas we're going to discuss mainly focuses on this liability and liability shifting aspect of it. And that's the next part here. One of the key aspects of any professional services agreement is indemnification, the indemnity clause. It is a contractual provision that shifts liability from one party to another. The purpose of indemnity provisions is to allocate risk in advance. It is saying that we are indemnifying you because of some damage we may have caused. That seems pretty straightforward in concept, but the devil then becomes in the detail of the actual language. So what happens in litigation involving bad indemnity clauses? As I was already discussing, professional liability insurance policies do not cover attorneys' fees and costs involved in defending your client unless a state statute provides otherwise. So if you agree in a contract, which is often crafted by your client or owner or public entity that says you will indemnify, defend, and hold harmless the client, the defend obligation is not covered by your insurance. Your professional liability insurance is only going to defend you, the architect, your firm, your employees. It is not going to defend your client. Sometimes with an unsophisticated client or owner, you have to explain this because it is completely a different concept than is provided under a CGL policy or a comprehensive general liability policy that the contractor has and the subcontractors. They will be providing for a defense and in fact be naming the owner as an additional insured. This will not happen under professional liability policy, and you cannot agree to contract language that says that you will either defend or name your client as an additional insured. If you do so, like we already discussed, you will receive an automatic reservation of rights letter from your insurance carrier saying this risk, this exposure goes beyond what we're covering, and you will take that personal exposure and risk of damage there. If you have bad indemnity, you will also likely pay more money or more risk at a time to evaluate the case and settle it because of the increased exposure and risk of paying attorney's fees or for an indemnity obligation that goes well beyond what it should. Higher payments to settle case affect insurability and your premiums. So what does a good indemnity clause look like? What you're seeing on the screen here is our markup of an indemnity provision that was a bad provision made good. So in this particular case, this is a provision taken out of a case in California, which stood for the proposition that the indemnitor, the person obligated to indemnify, owed a duty to provide an upfront defense. It also stood for the provision that they were going to pay for everything under the sun and without having been found liable or responsible. So in this case, we've gone through and shown what a markup looks like. In this case, it's limiting it to a reasonable number of indemnities, i.e. the owner and its employees, officers, directors, as opposed to additionally agents. We've also limited it to the extent caused by. That means it's proportionate so that it's not a joint and severable liability exposure, meaning if you're in joint and several liability, if you're responsible for 5%, the other person can't pay the 95, well, you're still paying the 100%. Yes, oversimplifying, but that's the risk. You want it proportionate. And then you want to have it clear that it's tied to your negligence. With indemnity, the minimum trigger should be negligence. It's not mere errors and omissions. Like John talked about on the standard of care, the standard of care means a lack of professional negligence, not mere errors and omissions. The standard of care is not perfection. You don't have to be perfect. So to that extent, negligence is the key factor in that consideration. And then lastly, it is best not only to set the parameters and clear understandings in a contract, but to make sure everyone's on the same page, is to include language that says the consultant shall have no upfront duty to defend. Sometimes it's good just striking the word defend, but this really including the negation of that duty, make sure everyone has a clear understanding of that, so you're not wasting time down the road. So this is the markup. The next slide shows kind of what it looks like more in a cleaner version. And that is to the consultant agrees to the full extent permitted by law to indemnify and hold the owner harmless from any damages, liabilities, or costs, including reasonable attorney's fees and costs of defense, claim damages, to the proportionate extent that such claim damages are caused by consultant's negligence or willful misconduct. Willful misconduct is not covered by your insurance, but it's also, if you've committed it, you cannot escape responsibility for having been willfully bad. It's an intentionally wrongful act. So you can't really escape responsibility for it, but know that if you've done something that bad, it's likely not insurable. So that's just something to be aware of. And then lastly, again, the language, the consultant shall have no upfront duty to defend the owner, that shall reimburse reasonable defense costs to the owner to the same extent the claim damages are determined to have been caused by the negligence or willful misconduct of the consultant, or as the parties otherwise agree in settlement. So the insurance that your professional liability carrier provides will include, as part of those damages, your client's reasonable attorney's fees and costs, but it has to be tied to you being negligent. So you can't agree to provide it up front, as there has been no determination that you are responsible. So it's all the devil in the detail in the language. And that's how you have to often address this with your client and explaining, we can't agree to an upfront defense. It's not covered. We're not trying to avoid responsibility. We just can't do anything upfront. You have insurance, you know, your contractor and subcontractor have you as an additional insured. So if we're responsible, you know, our policy is going to stand up, but it has to be at the end. Has to be a back end obligation. So that's an important aspect of that. All right.
All right. Other key provisions. So I want to be very clear here. We can spend literally hours and hours talking about other parts of the contract to consider. We wanted to highlight some of the big issues and relevant to insurance, but there's clearly a lot of elements of contract that you should be cognizant of. We've seen questions popping up throughout today, and hopefully we can answer some of this through this phase. But the first one is billing and payment. You have to get paid. And a lot of times we're seeing ownership delay payment, delay payment, delay payment. And then at the end, when you say, well, I need to get paid for my work, they come in and don't pay you. And then what do? You bring a lawsuit to get payment. Guess what they do? A counterclaim against you for errors and omissions. And then you're in a very complex and expensive process. So billing and payment has to be clearly defined, that you are entitled to be paid for your work. And if you do not pay, and again, you can spend hours on each of these, but if you're at a minimum, if you're not being paid, you have some right to stop work or some penalty or something in the payment process. I would also recommend including some language saying that, you know what, you have a limited amount of time to review the bill. After that point, if you do not object to the bill, you accept the bill. So that's billing and payment, needs to be in every contract. Next one is construction observation. We know in the majority of cases, construction observation is always a primary driver of a lawsuit. These owners and developers and contractors that hire you typically can't point to anything particularly on the plans. Yeah, there's some minor deviations, minor imperfections, but nothing that would drive a high value damage award. So where they go? They go into construction observation. Why? Because their experts can subjectively discuss that issue. So make it very clear in your contract when you review it that construction observation is clearly defined and that it explains not just what you're going to do, but what you're not going to do. Next category, dispute resolution. There was a question about whether it made sense to go into litigation or mediation. Dispute resolution essentially is an avenue where you can try to resolve your claim either before or even during litigation. Typically, contracts will have several tiers. The first tier being a principal conversation, followed by mediation with an approved third-party mediation center like a JAMS, AAA, and then litigation or arbitration. Arbitration is essentially litigation with just one trier of fact, an arbitrator. So it's important to, when you review your contract, to assure that you understand the dispute resolution. We always recommend having multi-tier dispute resolution opportunities so that you're not expending time, money, and effort in litigation. Next one.
John, just on that point real quickly. Mediation, understand that mediation is not binding. All right. Arbitration for the most part, certainly in commercial contracts is set forth as a binding obligation, a binding decision out of it. When you go to court, you get a judgment that's a binding decision. Mediation is a opportunity to present your case both from a merits perspective, a damages perspective, and a defense perspective, and really air everything you want, and enable a mediator who is a neutral party to both evaluate the case and try to resolve the case. So regardless of when it occurs, whether it be pre-litigation or pre-arbitration or during the proceedings of litigation or arbitration, we often find it's a advantageous opportunity. We learn things about the other side. The mediator might point out some weaknesses or strengths to our case, and or damages claimed or sought. So all in all, it's something we strongly recommend.
Yeah, one thing to note with mediators is in the contract, you want to have language that allows you some control over the mediator. We see a lot of times in mediations, the owner has its, I don't want to say friend, but let's just say somebody who's more receptive to their arguments. They're supposed to be neutral. They'll act neutral, but kind of hard to be neutral when you keep getting business from one particular person. So make sure your language that you want to control the mediator, so it's mutually acceptable mediator, not just what the owner wants. You'll see in a lot of these contracts, the owner will insert a mediation clause, but it's one-sided. They get to select the mediator. So be wary of that. You want to at least have an opportunity to control that element. And then arbitration, just to dovetail on some of what Peter mentioned, arbitration is binding, unless you specifically say it's not, but most people will require it to be binding. The difference is you're going to have not a jury or a judge, but an attorney like myself with years of experience sitting there. And generally we find in arbitration a significant amount of costs, almost akin to litigation. And then the arbitrator may not give you the right decision, may end up splitting what we call splitting the baby. So arbitration isn't always the best avenue. So in dispute resolution, you can put an arbitration clause, but we will recommend some flexibility. In other words, make it an option, not an obligation. Moving forward, other elements to look for is governing law. You don't want to know how many contracts we've seen in the state of Nevada where the law is Florida or Iowa. It's a Scrivener error, clearly. But if you agree to a law that's not in this jurisdiction, you may be subject to requirements that you're not typically used to. And Nevada has very favorable laws. So you want to make sure that when you review this, that you have the right jurisdiction.
Yeah,
go ahead.
And just to address a couple of questions that I'm seeing with respect to indemnity. Well, first, even before that, is there's a question about, does the standard of care vary from state to state, East Coast, West Coast, etc.? And the answer is yes. Each state has a particular building code that they're complying with, a particular practice, particular experience on different types of projects, industries, all of that factors into what the standard of care is in a given geographic locality, as well as obviously the types of projects, and again, and most importantly, on the specific language of the standard of care in your contract. So that's on that. Then there's some questions on indemnity. Can you refuse to have an indemnity clause? Yes, you can. We always say no indemnity is better than bad indemnity. But it's very rare that you will get that type of situation or have the bargaining power to say that, no, we're not going to have any indemnity in this contract. More often, the reality is you're going to have a clause, you're going to have to make it insurable and reasonable. Is indemnity to be reciprocated equally between client and consultant? We always, certainly out of the blocks, in any proposal that goes out that has terms and conditions and or first pass of contracts, would want to propose mutual indemnity. And so that the client indemnifies you for their negligence and that you indemnify for yours. The practical reality is that owner or client may have a better bargaining position than you and say, well, I can go to the architect down the street and they're not going to push that back on me. And so it becomes more a business decision based on superior or inferior bargaining power. So that is something that is mainly project by project, contract by project. So that is that. So, John, sorry to interrupt. Keep going.
No, that's fine. Peter has mentioned significantly the elements of indemnification. One distinction that we haven't talked about is the duty to defend. You will see in indemnification provisions the obligation to not just indemnify, but to defend. You have to be 100% on point when you see that kind of language. Defense, defending. Anything that sounds like you have an obligation to defend somebody, not just indemnify them, but also defend them from a claim. And here's why. In the state of Nevada, the duty to indemnify is triggered when there's generally a finding of negligence or an obligation where you have to indemnify or hold somebody harmless. That is typically found at the end of a case during the judgment phase. The duty to defend arises not at the end, at the beginning of the case. All it takes is somebody to write a letter and say, under the contract, you have a duty to defend me for these particular claims. And the law essentially says, if there is a potential that you have that obligation, you have to provide a defense. What does that mean? You have to get an attorney, or you have to pay their attorney, fees and costs throughout the litigation. If you do not, at the end of the litigation, let's say hypothetically, you're found not liable. Yay, I won. Oh, by the way, here's a $600,000 legal bill. What? I won. I'm not responsible for any of this. Well, guess what? You violated the duty to defend. It triggers at the beginning, not at the end. So every contract needs to address that. Strike it, strike it, strike it. If you can, strike it. I cannot emphasize that point enough. A couple more of these items. We could go through so many of them, but instruments of service ownership. Oh my God, we see this all the time. Your hard work, you draw the greatest design for a project and you have to give it to the owner. And guess what? He doesn't pay you. Then what? The owner then taps onto this language. Well, I own the plans. And so when you sign a contract, be very careful of who owns the instrument of service. Now, generally speaking, we see in these provisions that the owner will own the plans, but you own the standard details. This is your work product. But sometimes that's not true, but generally we see that. I always encourage my clients to push back a little bit and say, okay, you own the plans, but you have to pay me. Once you pay me in full for all fees, you become the owner of the plans. So there's some negotiations, there's some language you can play with, but be very careful when you review the contract, who owns the drawings? Because guess what? It becomes a problem when they don't pay you. And you say, well, these are my drawings, I'm going to walk away with them. Well, no, you won't. And the other element is, what if the owner wants to take your beautiful design and apply it to a project in Macau, in Italy, wherever? Be very careful that your language in there gives you some level of control over that element as well. If you can get some permission, in other words, you can get a licensing fee of some kind. Those are things to look for in this phase.
You have U.S. copyright law in your favor in this particular position, as architectural works are recognized for copyright protection by their author. You also have a great local state statute that addresses this, but also, it says you should, in your contracts, you should establish that you own your plans and specifications. As John mentioned, you can approach this in either giving a license and or transferring ownership, but you don't want to give away that up front. John mentioned upon payment, that's great. His point about reuse is great. Unless you design something as a prototype design, and that is a whole nother topic for another day, you don't want to allow reuse without just compensation.
Yeah. And I will add, owners will fight you on this. When we negotiate contracts, we always try to put in caveats that give you some control over the plans. Because you control the plans, you can also control payment. I think some people were asking about how to control payment. Well, this is one avenue. If the owner can't use your design because they didn't pay you for it, then you can have a lot of leverage on the owner to get your invoices paid for, and you don't have to go through a mechanics lien in the state of Nevada to recover your fees that you're entitled to. So again, it's very hard for sophisticated owners to agree to some sort of limitation on the ownership of the drawings, because they say, well, it's my projects, my drawings. But to the extent there are some areas where you can create some level of control, and I would tie it to payment. That's where we found that we're able to get some level of control back. You own it once you pay us in full. The final invoice, it's yours. And then you have and obviously in line with that, you'll have an unlimited license to use that design. Or you can also put in there a licensing fee. So again, we could spend hours on these topics, each one of them, but these are some items to know. Moving forward, I'm going to mix project description and scope of service. Standard care we talked about, but you kind of mush these all together because it is critically important in a contract to define the project. And most importantly, what you're going to do. If you leave a contract open-ended or not, or vague as to what exactly you're going to do, guess who fills the void? It's going to be some expert. He's going to add construction site observation or more, or even worse, construction site inspection. He's going to add maybe parts of the project that you weren't paid to do. We all know that when you get into a project, it can blow up. Something you thought, I'm going to do this, all of a sudden it's not that. It's a lot more. It's critical in that circumstance that you have a clearly defined project, clearly defined schedule and budget, and if the project description changes, the schedule changes, the budget changes, anything that expands the scope, right? Because when you get expansion, this is where your fees go up. Time and materials start to add up. Well, guess what? This is where the owners stop paying. They'll take the benefit you give them, but they won't pay you. So it's critical to have these project descriptions and scope of services clearly defined. And when the project changes, you have to have another contract that if you're going to expand it to Y, you better have another addendum to the contract that includes that scope, that includes that service. And most importantly, if you have some really good contractual provisions, you want that to transfer to the expanded scope. If you do not do that, you do a handshake, a verbal agreement, guess what? That's where the problems always rise on payment issues. Now you're doing stuff called scope creep outside your scope that you agreed to do. You can scope creep yourself into some areas of practice that are not even design professional. They will ask, and ask. You need to push back. You need to define your scope of service and your project clearly. And we talked about standard of care. If you have any further questions, we'll address it at the end about that. But termination and suspension, every contract has an end. A successful project involves you get all your fees, you win great awards, they come back to you down the road. Well, sometimes that doesn't work out that way, right? So typically in contracts on termination, there's something called termination for convenience. This is where the owner decides he no longer wants to use you. He will terminate you. Generally, there's a 7, maybe a 10-day notice. The agreement says you will get your fees up to that point, and then dovetailing with the ownership of the instrument, other parts of the contract will define who gets the plans. Typically, the owner will. A lot of times these are amicable. Maybe the project is going in a different direction. Maybe there's a internal disagreement on how to do this. Or maybe the owner has got a buddy who just got his license and decides he wants to use him. That is very typical to have a convenience terminology term in the contract. But the other type of termination is not for convenience, it's for default. And generally the contract will define what those are. Now you can also put in your contract termination for default for non-payment. That is acceptable. But typically there will be a laundry list of items that the owner says you didn't do, and therefore I'm going to terminate you from the project. Again, we generally see 3 to 7, maybe 14-day notice, written notice before termination. But you kind of can see it coming down the road. The owner is starting to be difficult. Communications are collapsing. Next thing you know, you get a notice of termination and instructions to turn in your work product. And then that's where the dispute on fees will arise as well. Well, I'm not paying you, you gave me a defective design. So in the contract, understand your termination requirements, your suspension requirements as well, what you can suspend for, what you can term for. There are clear elements of both of those parts. Typically, non-payment gives you an opportunity to suspend services until payment is made. In reality, design professionals want to help the owner, right? So you end up kind of ignoring that requirement, and you end up doing more and more and more. Next thing you know, you're down so much amounts where you finally have to throw up your hands and say, I can't do any more. We would encourage more of a proactive approach if the owner's not paying your fees, and comply with your suspension termination requirements in your contract. And we would even recommend you cite it. If they're not paying your fees and you're starting to see your fees getting 60, 90, 120 days behind, and your contract allows you to suspend services, obviously you want to work with the owner. That'd probably be the first recommendation, but document it. If the owner's not going to pay you after your attempts to resolve the issue, document it and explain why you're suspending your services.
Let's be clear though. You have to make sure and oftentimes insert those rights of the architect to suspend termination. There may likely be a termination for cause in there, but the right to suspend is often not in your agreement, especially if it's an owner drafted contract. So that is something that you have to affirmatively insert into a contract, or you won't have that right.
Okay, we gave you the bad news. What's a good contract look like? All right. These are, again, a lot more detailed than today's purposes. We can get into each one of them, but things you can look for in a good contract. And I'm going to select a couple of them. And I invite the rest of the panelists to add their 2 cents on anything that they like to add. But an assignment clause is one of the things you want to look for. Owner contracts will typically allow them to assign the contract either to a financing entity or maybe even to a number of different entities that the owner elects to do. We typically recommend that if you can negotiate that to give you a right to prevent assignment. Maybe you will not be able to do that with the financing entity, but maybe other entities that the owner just randomly decides, you know what, I don't want to deal with this project. I'm going to give it to this other guy. And he may not be the guy you want to work with. So in an assignment clause, you can add language that says you have the right to, you have to give your written approval for the assignment. That's something you can add, but in our negotiations, owners have been very careful to strike that kind of language. Nevertheless, a good contract will have that level of control. Change conditions. I really, really want to emphasize this one. This goes back to a couple slides earlier where we talked about your scope creep. As you all know, when you get into a project could look like X and it completely becomes Y. And again, this goes into not just fee elements, but also your scope. If there's change conditions, something arises during the project that expands your level of involvement, changes the design, or the owner just simply decides, you know what, I don't like how you designed that interior. I want something completely different. You want to have conditions, change condition provisions in your contract that allow you to either modify your fee or allow you additional protections so that if there are change conditions that weren't anticipated, but they arise during the construction process or the design development process, you want to make sure you have these provisions to protect you so that you're not left scope creeping out of it, because owners will change the design. And sometimes they don't pay for that. They'll say, well, I want this change, and it impacts schedule, impacts fees, causes delays, and may end up costing you a lot of fees that you weren't anticipating, for which the owner later on doesn't pay. So be very careful of that provision. You want to have a good one in there that clearly defines what to do when there's change conditions. Next one is consequential damages waiver. What is that? Consequential damages, you can best think of it as a particular type of damage that typically arises. Delay is the most common example. It's a consequence or the result of a defect. You go into a project, you design it, there's a defect that arises, and next thing you know, the project, particularly if you're in hospitality or casino work, the delay could be years. And guess what? Sometimes the cost of delay is a lot more than the cost of a defect. We had a project where there was a delay, 3 months. And guess what? The cost of defect, let's say under this example, let's just say it was 100,000, just hypothetical. But the delay was 10 times that, $1 million. Of course, these aren't the exact numbers, but you get the point. Sometimes the delay is higher than the amount of the defect. So you want to always have this kind of language. And we've seen owners push back on this. They love their delay and consequential damages. So you want to have a really solid one that waives that. You know, if there's a defect, I'll pay for the defect. I'm not paying you your loss of opportunity or your loss of business, lost profits, you know, delay, any of those types of damages. They all fall under consequential damages waivers, and they are excludable in the state of Nevada. I will go into some of the bottom ones like delay, force majeure. Force majeure is a type of delay that contracts will excuse. For example, you have a riot right in the middle of Las Vegas. We have seen in contracts provisions that do not give you an out for that situation. Recently in a negotiation I had with a rather large company, they didn't even know what force majeure, why it was in there. And yeah, it's very rare, a war, you know, a war in the middle of America might be rare, but you never know where your project is located. And if you have some sort of a war, some sort of a riot or government change, particularly if you're working on a project outside the United States, it's critical to have that kind of provision in there so you're protected. Next one is, I'm going to jump over to limitation liability, even though there's one about job site safety. I'll just touch upon it very briefly. There is language that you want to have in your contract that does not make you responsible for construction safety programs and protocols, OSHA. We know during construction, people get injured. We know during construction, some kid will jump over the fence and get injured. There is language you can put in there that will prevent you being responsible for that. That's the general contractor's responsibility. You shouldn't be responsible for job site safety under your observation services. Here's a big one, and this is why I wanted to jump to this. Limitation liability. In the state of Nevada, limitation liability provisions are enforceable. Now, when you make a limitation liability provision, you have to be very careful to not write something that a court of law down the road is going to find offensive. For example, you can write in your contract that your total liability is capped at $15,000, right? But the project cost is $100 million. Now you get sued. There's a defect that costs the owner group $10 million. Yeah, under Nevada law, limitation liability provisions are upheld, but the court is going to use its own reasonableness scale. Is it reasonable, even in a sophisticated party situation, for anybody to say your max cap is $5,000 on a multi-million-dollar project? And we've seen limitations courts, when they analyze limitation liability, say that is not reasonable, and they will not enforce it. So when you do a limitation liability provision, first assuming that the owner group will accept it, you want to make sure you understand your project in terms of its cost. We have seen limitations that are upheld at $50,000, fees, or policy limits, all three of those categories. Again, it goes to the size of the project and your scope of work. If you are running a multi-million-dollar project, you're not going to get away with a $10,000, $15,000 limitation liability. However, you can, if you have sizable fees or policy limits, for example, a $5 million limit, you can enforce that under those circumstances. Again, your fees can also be let's say $250,000 in a multi-million-dollar situation. We've seen that upheld. So again, when you write a limitation liability, if it gets accepted, make sure you understand the scope and size of your project, because down the road, you do not want a great provision being struck for not being reasonable under the circumstances. Another, I'm going to jump over to sole corporate liability. What is that? Well, when you get sued, a clever plaintiff counsel can sue you personally. They can sue you under your license, 623 license, or any other type of professional license. And they can sue your company. Now, your insurance company will defend you personally as well and cover you personally as well. But it's a lot of stress. A lot of our clients don't like to be personally named. Well, you can avoid all that by having this clause, this sole corporate liability clause. Essentially says, if you're going to sue me, you sue the company. You can't sue the directors, officers, employees. You can't sue the principal in charge. This allows the protection of what you created a corporate entity for without the added stress of somebody coming after you personally, even if you're protected by insurance. It creates unnecessary stress. This is a provision that's routinely accepted because the owner doesn't care. The insurance is the same. He doesn't get any benefit other than harassment by naming you personally. So you want to have this clause. And finally, the third-party beneficiary clause. You have a contract with the owner. You don't want the contractor coming in and claiming rights to that contract. He's a third party. He didn't sign off. He didn't give you money. You want the contract to just be with the contracting parties. So these are some general provisions that a good contract will have. Let me point out a couple more items to avoid when you do your contract negotiations. Guarantees, warranties, certifications. This is essentially, I'm guaranteeing that my project will have no issues. It's akin to strict liability. It may not be insurable. Also, watch for standard care and strike representation stuff because they can sue you for misrepresentation. Other language to watch for is supervision, inspection. You want to change those to observations or periodic visits. So that's the language to avoid. Next slide. These items we've gone through, some of them like highest, first class, best.
Yeah, these.
Yeah, go ahead. I got it.
Yeah, sure. These provisions are just a reiteration of things we've already talked about. You know, this one says non-compliance with California Civil Code. Well, in Nevada, that's non-compliance with the public rights indemnity statute. That's a problem. But some of these other things are things we've already addressed. So on the following slides after this, we're providing you with some sample clauses here, some of which builds on what John already said. There's a waiver of consequential damages language you can insert that we've already discussed. The next clause is one form of limitation of liability. Likewise, what John discussed, this particular clause is a limitation tied to available insurance policy limits. Even with the AB 398 language, this is still a clause that can be used At worst, it's limiting to your stated policy limits. At best, if we get the commissioner to issue the regulation, it will limit it to what's ever left, the available limits, and that's certainly a best case scenario. You can also, on the next slide, have a provision tied to a lump sum. In other words, your liability overall is capped, as in this example, not to exceed $1 million. That might be somewhat of a risk if your insurance limits are $1 million per claim, but if you have, say, a $2 million policy, even if it gets reduced by a competing claim or defense costs or whatnot, you're still covered. But there is certainty in what your exposure is. This may not be something where your fees are $75,000, but if this is a $5 million professional liability or professional services fee, then this is probably a reasonable limitation of liability. Then the next slide is one that we often see overseas for international contracts, is you'll be able to secure a limitation of liability tied to the total fees you were paid. That, again, is project by project to evaluate what those fees actually are, and is in line with both the risk and in line with what your insurance coverages are. So on that, the next slide is what John was talking about with respect to sole corporate remedy. This is likely not a clause you'd be able to secure in a public works, public entity type agreement, but on private projects, you should almost insist upon this type of language, so that both in this case, it's written as a mutual provision, so that you will not expose the owner's individuals, nor your own shareholders, officers, and directors to liability. And it is a reasonable commercial provision that should be accepted. If you have an owner up front that isn't agreeing to this and is basically saying he's going to go after your house and your car, then you should seriously take stock in whether you want to do business. This is one of those provisions that needs to be there. All right. And then next slide. Then Scott's going to take over here after Scott's addressing some of these issues, which I know are some of the subject of a few questions. Then after that, we'll take a few more questions as time allows.
So now we're going to look at limitations to actions against design professionals to consider in contracting with regards to the applicable statute of repose and statute of limitations. With regards to the statute of repose, NRS 11202 states that Nevada statute of repose is 10 years from substantial completion of a project. With regards to it does not apply to indemnity or contribution, an action against an owner or keeper of a hotel inn, motel, boarding or lodging house, or product defect. The date of substantial completion commences on the final building inspection, notice of completion, or certificate of occupancy, whichever is the latest in time. For notice of completion, it is the date of recording, not when it is signed and notarized. And that's based upon a case, Dykema versus Del Webb Communities.
Yeah, Scott, for that notice of completion, a lot of times we ran into this in a particular case where the notice of completion was like a month before it was recorded. And the Dykema case and Nevada law says it's not when it's signed or notarized that's important, it's when it's recorded. And that's kind of confusing because it's kind of in the control of whoever owns the notice of completion. Now, you would assume somebody wants to get that notice of completion submitted quicker than possible. But sometimes we see them drag their feet on it. And guess what? It extends the statute of repose. And 10 years down the road, you think, oh, I haven't seen this in a while, I'm clear. You may not be. So that's a very critically important element of when the statute of repose commences. And think of statute of repose as, and we're getting into statute of limitation, but think of statute of repose as the outside boundaries of a claim where somebody can sue you. In Nevada, it used to be 6 years, now it's 10. So we recommend for your document retention to note that 10-year rule and try to at least hold on to your plans, key contracts, key communications for at least 10 years.
Then we go ahead and move into the statutes and limitations. Here are some notable statutes of limitations that we have identified for you. Nevada applies 6 years for any judgment or breach of contract, 4 years for professional negligence on an oral contract, 3 years for a breach of statute and a negligence per se type situation, for fraud, 2 years for personal injury, and the time shall be deemed to date from the last transaction or last item charged or last credit given or last payment. However, there is a discovery rule that could extend the time period, especially for personal injury. And what that means is, with regards to a discovery rule, is when you actually discovered that you were injured or should have discovered that you were injured. Also, with regards to the limitation may not commence until a claim accrues in breach of contract situation or a subsequent agreement can reset the time period.
So this is what I mentioned earlier. Think of statute of repose as the outer limits. But within that, you have things called statutes of limitation. 6, 4, 3, 2. There's even a 1 year. Now, somebody asked about mechanics liens. Mechanics liens has a different requirement. For example, you have to commence a lawsuit within 6 months. You also have to give notice of your lien within very specific time periods. So again, this is just general statutes of limitations. There are others that would govern elements of your case, or strike that, elements of your claims that you may have. But typically 6 years for breach of contract, fee recovery. On judgments, you can renew a judgment, so it could actually be in perpetuity. And so be wary of that. The discovery rule applies primarily in fraud as well. When you discover the fraud, so let's say you got defrauded 5 years ago. Wait a minute, 3 years, I can't bring anything. Well, the discovery rule can apply. Breach of contract, we've seen both sides of the argument. I've seen an argument where they say the breach starts the clock. But I've also seen an argument where somebody argued successfully, now I don't know if the court was right on this, that the start of the clock was when they executed the contract or completed the contract. So for breach of contract, it's a little bit I don't want to say it's as clean as like personal injury. You know, you get hit by a car, you clearly know or should know when your claim rights commence. You're in the car accident. Breach of contract is a little more different. So I'm going to offer that as some food for thought. But these are the general statutes of limitations. And then with that, statute of repose is the ultimate outer layer. This is primarily in construction defect litigation. So keep in mind, 10 years, 6, 4, 3, 2.
All right, and with that, we'll try to get to some of your questions. One of the questions is, there's a few based on using the AIA contract documents, and in particular the B series, which are the architectural professional services agreements. We do strongly recommend using these forms of agreement, as they are a standard, a commonly acceptable form. When you're able to start from that basis, the negotiations tend to go a lot smoother, as opposed to a owner or client driven contract that is probably twice as long and so pro client or oriented that you're spending most of your time just revising almost every single paragraph or line. That's not to say that we don't think the AIA contract documents don't have rooms to be modified or can be improved to better fit a particular type of project. Of those, the typical provisions that we tend to address are ones that address, one would be probably Article 6 with respect to the cost of the work. We try, I mean, unless you're dealing with a public entity or public project where the architect is oftentimes required to provide cost estimating and design specifically to budget. We like to revise that language to add a little more flexibility, especially with a sophisticated owner developer who has their own cost estimating team or an early engaged general contractor. Let them handle that cost estimating and really focus your design on compliance with certain benchmark estimates so that you're not stuck with a situation down the road when it's gone out to bid and the lowest qualified bid is above, the budget, and then you're redesigning way down the line and after fees have been expended and you're doing that for free. So that's one area we focus on. Also, a lot of these protective provisions that we've been talking about, such as sole corporate remedy and limitation of liability are not in the AIA agreements. There is also no indemnity language as a standalone provision, but oftentimes we tend to err on including those so we get the language we want, other than getting it as a pushback from an owner with more onerous language. There's also provisions dealing with existing conditions. Code compliance can be modified, force majeure, as John discussed, and maybe some better language or more thorough language dealing with ownership of documents. We're not really wild about the architect serving as the final decision maker with respect to conflicts. So we tend to modify that language as well. But overall, the AIA documents are very good. I would also mention perhaps in the scope of services section and the scope of services section in any contract, make sure it's reflective of what services you are actually providing. One distinction that the AIA contract documents do not make is their use of the term contract documents during the construction phase or the construction administration phase. You, as an architect, are generally not out there with not only the permitted set of construction documents, but the owner contract and the terms and conditions and all this other stuff. Your observation as to the contractor's work should be limited to general conformance of the permitted set of construction documents, not all this other stuff. And so that is one change we often make in that regard, and fine-tuning those types of responsibilities. Other questions?
Yeah, Peter, there's a question about someone discussed the case involving invoices, meeting notes, and the client claiming they never received it. This is one topic that I think, and not to answer the specific question, but to talk about it in generalities. Documentation is critical. Critical. We talked a lot about contracts, but we also need to make sure that during the project, you are properly documenting significant elements and changes during the construction or during the design development phase, when the owner wants to change up the design and you run off and you start doing all that, document it, send an email, get confirmation, discuss the risks, discuss the factors. Now, I'm not saying you do a full-blown interpretation email, but make sure that anytime there's something that you feel like, I don't like this, it's that kind of gut feeling that there's a change or the owner's making me do something beyond. You want to document an email, a letter, some kind of memorandum, something in writing that gets confirmation from the owner. For example, the owner wants to change the design. Okay, we can do that, but it's going to cost you another 50 grand. Perfect. Let's do it. Go. Rock and roll, baby. Well, get that in writing. Get the owner to sign off on it. Yes, I understand. It's going to cost me more. It's going to cost me more in time. So if you do not document, then you are going to ask the trier of fact to speculate on who's right. The owner is not going to go into a trial and say, you know what, the architect got me. I asked for this change. You got me. I owe him 50 grand. He's not going to say that. He's going to, I don't recall. Well, guess what? When you have that nice email slide across the table, well, you don't recall. Well, let me refresh your recollection. Oh yeah, now I remember. So document. That's some, even during the project. I'm not saying you have to write every email under the sun, but definitely anything that's significant, changes to design, changes to scope, non-payment, anything you can to help yourself if there is litigation down the road, we would recommend that. Document and preserve the file. Remember, 10 years statute of repose. Don't burn it after 3 years and then get sued 8 years later and say, well, help me. Where's the document? Well, I burned it. No. So you want to preserve that as well.
If it's not in writing, it didn't happen. I think I mentioned that before. So another question is with respect to limitation liability clauses. Is it a separate signature line needed or just one signature line that use the entire contract? It is a limitation liability clause must be obvious, must be seen as being negotiated, must not be hidden. So yes, a best example of that would be to have a separate signature line, for it to be in bold, to show that there was negotiations back and forth on it. But it still may be enforceable even without a separate signature line. That would just be belts and suspenders best practice on that. Let's see, what else do we got here?
Yeah, there's a question, Peter, about whether interior designers have to have the same type of insurance as architects. Interior designers have depleting policies. So under AB 398, yes, it would apply. You don't get an exemption if you have that type of policy. It's not based on who has the policy. It's with respect to design professionals. If you have that kind of type of policy, a depleting PL policy, yes, it's going to apply, and yes, you have to comply. So again, we would recommend talk to your respective insurance brokers. We cannot give insurance advice, nor would we, and they can give you the most up-to-date information on how to comply with AB 398.
We have probably time for a few more of these questions. If not, we'll try to respond in writing. But one is an architect required to provide construction observation? And you would be surprised that the answer is no. If your contract says you are, then you are. But not, the standard of care does not obligate you, or there is no other obligation for you to provide that. It might be imposed on a certain public contract code type of situation or otherwise. It's different from, say, a structural engineer having to observe and issue inspections and certifications. But an architect, if that is your scope, then make sure it's a scope that's defined in your contract, is accurate to what you're going to do, that you perform to it, and that you get paid for it. If you're not, then make sure your language adequately addresses the fact that you're providing basically services through obtaining a permit, that you're providing whatever you may have agreed to limited services beyond that, and that everything in that regard is governed accordingly. So just be explicit about what you're going to do.
Yeah, another question that come up, we touched upon it a little bit, is mechanics liens. Somebody asked, what's the statute of limitations? Well, it's a breach of contract. It's 6 years, but that's not the time limit that you're most concerned with. What you're concerned with is mechanics liens where you can bind the property. Again, this is a leverage opportunity for you. The deadlines are in Nevada Revised Statute, Chapter 108. And there are certain requirements. Again, today's presentation is not going to get into the meat and potatoes of that. But if you want to know the source material, it's Nevada Revised Statute, Chapter 108. It contains the requirements for dealing with residential, non-residential. There's certain notice requirements. There's a form you got to comply with. You can record. And what it does is it gives you a right to essentially bring a suit to recover your fees and costs. But again, the time period is a lot faster. So a lot of people say, well, you said 6 years. Yeah, you can still sue for lost fees in a 6-year time period from the breach. But if you want to take advantage of the rights afforded to you under Chapter 108, then you have a significantly shorter amount of time. And another question is, well, when can I file it? Contractors, remember this, the Contractors Board had a hand in writing Chapter 108. And so it's really written for contractors, subcontractors. There's even a kind of a tier system on who gets to go first when there's competing liens. Guess who's first? The contractor. Guess who's last? Design professionals. So be wary that 108, not just time period, but if you have multiple liens against the property, and let's say the owner goes belly up, you may not even recover your money. Short answer, 6 years for breach of contract, but for mechanics liens, it's significantly less. Chapter 108 is your source.
Let's see.